April 94. As it appears that a large number of candidates with PhD had already been appointed on the basis of eligibility criteria specified by the educational authority. We do not think it to be equitable to affect their approval. We accordingly hold that the judgment delivered by the speech on 11th August 23 shall have prospective operation. The prospective operation of the judgment shall be only if those candidates who were appointed without any qualification or condition imposed by any code of law to the effect that their appointment would be subject to the final outcome of the case might have been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuit of a notice of advertisement whether period was stipulated to be a valid qualification. So this is a only such candidates shall not be discussed because of the judgment. We make it clear that this benefit is only for the candidates but appointed prior to the date of the judgment was delivered on 11th August 23. Mere selection of the candidates or the participation in the process is not entitled for a benefit under our present order. Now this is what I rely upon now. Moreover, the candidates having 8 qualifications for appointments we are protecting in this judgment will have to undergo a bridge course and we direct the educational authorities to devise such course to be applicable for each state and union territory within a period of 1 year from today. This course shall be only for those appointees who have been engaged with BA degree only in the subject course under the conditions stipulated in the earlier part of this order. Ncte shall design such course under overall supervision of the Ministry of Education, Union of India. Upon formulation of such course, the same shall be publicly notified and a time frame shall also be given within which the respective candidates shall participate therein. Failure of any candidate to participate and complete the course within the time frame to be given by the concerned authorities will invalidate the appointment of such candidate. Now, in one of these, an order of the Calcutta High Court, page 90, next page, page 97 and page 99, middle of the page, because our appointments were under challenge in the Calcutta High Court. Page 99, if you will see the middle of the page, the paragraph in the middle. Page 99, now have it. Yes. The court was pleased to specify that service of only such candidates shall not be disturbed because of the judgment. The benefit is restricted only for the candidates appointed prior to 11th August 23. Here, selection of such candidates or the participation in the selection process will not entitle to get the benefit of the order. The Supreme Court laid down that the candidates having qualification and the appointments for protected by virtue of the such judgment will have to undergo a bridge course within a period of 1 year from the date of the order, that is within 7th April 25. This order was passed on 8th of April 24. The Ncte constituted a committee on 3rd of May 24 to design this bridge course. Thereafter, we will be making representations, asking RTI, all I think about 20 RTIs, when they say the committee is still deliberating. So now we apprehend that because of this, our appointment was protected only till today. We had to complete this bridge course by today, and now there is no bridge course, so we cannot obviously have not done the bridge course. So the sword is hanging over our appointment because of this.
Also, this state.
I'm waiting for the NCT methods.
Why are you not doing it?
We've already proposed it to the ministry. It's finalized from our side. Yeah, ministry yet to give us the approval to go ahead with this course. Today was like 8 April is the timeline, but much before that we have sent this to the ministry. And as and when we get the approval, we will immediately give the course.
It's all over India.
All over India. Order says
rules for the Union of India.
After the course is devised, within 1 year you have to complete. The course is not delivered, it actually coming before this court.
No, the protection is 7th of April.
Protection is subject to that condition.
What are given only 7th of April?
Appears to be that the Calcutta High Court has interpreted the Supreme Court order wrongly.
So obviously the Calcutta order now is coming. Obviously,
What is your interpretation?
It can be given certain extension.
What is your interpretation?
Well, we were to devise the course before 8th of April, which we have devised and given.
About this outer limit, what is your interpretation?
About
this outer limit of 7th April 25 or whatever.
They should be given an opportunity because as and when the course will be devised, then only they can take up that course.
So till then they should not be removed.
They should not be removed ideally.
That is.
Chaos.
Shall we record your concession? Shall we record your concession?
No, the course is actually under consideration before the ministry.
Oh, that is
the instructions.
That is what I am saying. So
until the course is approved and coming course notified, we cannot conduct that course again. That's the difficulty, man. So maybe MHRD is a party.
There are some but not appearing. The state is also not appearing. The union is also not appearing. The office report says there are some.
Okay, the matter has been taken out of turn on the plea of not counsel for the petitioner, that as per the order of the High Court of Calcutta, the persons the petitioners who have continued in service were required to undergo a bridge course to be devised by the Ncte, and within 6 months, and they had to.
The course was to be devised within 1 year from the date
Course
of the
was
order.
to be devised within 1 year.
That's 8 April 2024.
From 8th April 2024, and the petitioners and other similarly situated persons had to clear the same within the stipulated time,
Within 1 year.
within 1 year, 2024 or 23.
After notification.
The course is 6 months. That is the notification of NCTA also.
After notification, 6 months.
Yes, after notification.
After notification within 6 months. Full stop. Learned Council submitted that till date the successful completion by the petitioners was directed to be done by 7th of April, that is today. Full stop. However, Learned Council for the SPT submit that they have already.
I'm sorry to disturb you lot. There's a, page 96 of the Supreme Court order. It says that a time frame will be given. When we notify, the time frame will be given by the academic authority. Complete that course within certain time.
The NCT was required to devise a module for such a bridge course, and the petitioners had to complete the same latest by 7th of April of this year. That is today.
No. That's
the Calcutta High Court says.
That's Calcutta High Court says. But if we
That's why about the Calcutta High Court. I will say Calcutta High Court is an initial.
Yes.
Yes.
As per the direction given by this court, dated
April 24.
8 April
April 2024 in the detail. Page number?
Dinesh Sharma was
It starts at 88. I'll just give the
Let's go to page 88. Page 88. Full stop. Paragraph. The Council for the NCT submits that the Calcutta High Court may not have correctly appreciated the import, and further that the NCT has already framed a course which is now pending approval by the central government or UGC?
MHRD.
By the Ministry of MHRD, Ministry of Human Resources Development. Full stop. Full stop. Further, the Council also fairly admits that as per the Supreme Court order, the onus would be on the petitioners to complete the court within the stipulated time frame to be fixed by the NCT.
Absolutely.
Only after the scheme is framed and implemented.
And notified.
Full stop. Paragraph. With regard to the aforesaid, by way of a clarification, we direct that till the NCT bridge course is notified and implemented, and the course is offered to the petitioners,
Coercive action.
offered to the petitioners, and till the time provided for completion of the said course, no coercive action shall be taken against them.
Item 60, there is an application for impleadment to implead as party respondent, filed by Mr. Akshat Srivastava.
As a respondent, who is filed for impleading?
Akshat Srivastava.
Why should they implead you? Go stand for more. Yes.
From the state of Himachal Pradesh, similarly situated.
Consider it later. We just limited to that.
They all will start coming other.
Yes.
Lots of
No, we
podcasts.
are not going to enlarge the scope. We limited it to this and then we see what happens.
Cover it in appropriate.
Yes.
Like that.
But you are losing. It is your interest of the state which is being compromised.
Yes.
Disposing of the matter.
No.
So then also permitted to serve the standing council trustee.
The remaining respondents have been served, but as nobody has entered appearance, formal land counsel for the petitioners may take fresh steps for service, including dusty as well as on the standing side. The matter will be listed again sometime in August. Sometime in August we are putting it.
Lordship 68.2 is a freshly tagged matter. There's no notice so far.
In 60?
8.2, tally number 1422/2025. It's a freshly tagged matter.
Tagged with this matter.
Already tagged, but no notice has been issued.
Who's for 68.2?
68 and 68.1.
Sir Raza Fali.
No, the tag. It is coming for the first time after tagging.
No lordship. Previously also it was.
If there's a common order is coming with the by payment that the common order don't tag to Vasika. This is what has been last Vasika. Where is the last order? Yes.
Item 49.